how does appointment or how do appointments take place in judiciary, in higher judiciary? Supreme Court और High Court में judges कैसे appoint होते हैं? How do judges get appointed in Supreme Court and High Court? What does Constitution say? Constitution under Article 124 Clause 2. Under Article 124 Clause 2, what does Constitution say? Constitution says that judges will be appointed by President. You will see every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal. After, the President will consult with judges of Supreme Court, and in case judges of Supreme Court and High Court, and in case of appointment of judges other than Chief Justice of India, he would definitely consult with Chief Justice of India also. So what has Constitutional originally said, or even today, what does Constitution say? Constitution under Article 124 Clause 2 says that judges of Supreme Court would be appointed by President after consulting with judges of Supreme Court and High Court, those judges of Supreme Court and High Court which he feels necessary, but consultation with Chief Justice of India is compulsory in case the question is about appointing a judge other than Chief Justice of India. Got it? This is what Constitution says. Article 217, which is about High Court, says that same process would be used for High Court also. Every judge of a High Court shall be appointed by the President by warrant under his hand and seal, but after consultation with, अब High Court का जज है तो यहाँ पे तो Chief Justice of India, the Governor of the state, and in case of appointment of a judge other than the Chief Justice of High Court. So how would High Court judges be appointed? High Court judges would also be appointed by President, but President would consult whom before appointment? Chief Justice of India, Governor of the state, and Chief Justice of High Court in case Chief Justice of High Court is not getting appointed. In case Chief Justice of High Court is not getting appointed. This is what Constitution has said. President appoint करेगा judges को after consulting judges of Supreme Court or High Court as necessary. Got it? Now, what was the idea behind this method? Idea was to check politically motivated appointment. देखो, ऐसे तो President himself could have appointed, but those appointments would have been politically motivated. Those appointments would have been more political, but here consultation with judges of Supreme Court leads to what? It brings some neutrality. B.R. Ambedkar but had in Constituent Assembly clearly said, CA means Constituent Assembly, B.R. Ambedkar in Constituent Assembly had clearly said that consultation did not mean veto. That is, when President is consulting with the judges of Supreme Court or judges of Chief Justice of India, that does not mean veto. कि जो Chief Justice of India बोलेगा वही होगा या जो बाकी judges of the Supreme Court बोलेंगे वही होगा. It does not mean veto. It was said in the Constituent Assembly also. Now, in India, the interpretation of Article 124 Clause 2 has changed over the years, and thus we have two phases, or the process of appointment of judges can be divided into two phases, till 1993 and after 1993. Till 1993, हमने ये बोला है ना कि Constitution said that President will be consulting judges of Supreme Court. Consultation did not mean concurrence. Till 1993, President opinion was superior. But after 1993, whose opinion has become superior? Judges or collegium's opinion. They created the concept of collegium, and collegium's appointment has become superior. So we divide the process of appointment of judges of higher judiciary, High Court and Supreme Court in India, into two phases. In the first phase, 1950 to 1993, it was a executive-led appointment process. It was an executive-led appointment process. In this phase, it was not mandatory for President to follow the recommendation of the Chief Justice of India and other judges. President was supposed to consult, but consultation did not mean concurrence. This method was, but this thing was criticized. Law Commission of India in its 14th report has raised an issue कि if President's viewpoint is given priority, then politically motivated appointment can still happen and judicial independence may get affected. It may lead to erosion of the judicial independence. This was perhaps the first time when this thing was questioned. The process of appointment of judges was questioned in India. By Law Commission of India, it was questioned. Phase of collegium mode appointment. After 1993, how is judge getting appointed? The judge is getting appointed by the collegium. So, how did this system come into play? How collegium system come into play? So, first of all, what is collegium system? We should be able to define it. It's a system of appointment of judges in higher judiciary in India. This collegium system was created by judiciary or by judgment of Supreme Court, and it doesn't have constitutional or statutory backing. In this system, Chief Justice of India along with senior most judges of the Supreme Court takes primary role in the appointment of judges in the Supreme Court and High Court and transfer of High Court judges. This is collegium system. Now, how did the collegium system come into play? So, there are different Supreme Court judgments. Jैसे there was Santosh Sir case in 1977. When a question was raised, President is consulting judges of Supreme Court. Is that consultation mandatory? Or consultation is mandatory, but does President have to follow those recommendations? So, in Santosh Sir case, they said, the Supreme Court itself said, consultation can never mean concurrence. Consultation का मतलब ही है you are consulting. Later, in first judges case, SP Gupta versus Union of India also, the same judgment was repeated. Consultation did not mean concurrence. President will consult the judges of the Supreme Court, but it does not mean concurrence. But then, second judges case mein, in 1993, when what would happen? The transition would happen. Pehle it was primarily executive led appointment. After 1993 second judges case, what would happen? Judiciary led appointment will come into play. In second judges case, by a very thin majority. You will see 5:4 ka majority tha. They said consultation really meant concurrence. And President will be appointing judges of the Supreme Court and High Court in consultation, nahi, in concurrence. They said the Supreme Court interpreted the word consultation as concurrence. And they also said CJI's view enjoys primacy since she is best equipped to know and assess the worth of candidate. But the CJI was supposed to formulate the opinion. CJI say consultation is compulsory and consultation will mean concurrence because CJI is in better position to know the people who are getting promoted. But CJI will form opinion after, or will form his opinion through a body of senior most judges that was described as collegium. The collegium system came into play in 1993. Yahan pe collegium system was defined as Chief Justice of India along with senior most judges. Through them they will form an opinion and they will give that opinion to President, and President has to concur. President को सिर्फ consult नहीं करना. President, here they said consultation means concurrence. Got it? So executive can ask collegium for reconsideration. When collegium gives some recommendation, executive can ask collegium for reconsideration, but once the same recommendation is repeated, executive has to, or the President has to follow it. President has to follow it. Then came third judges case. Acha, second judges case mein one more thing happened. Ek to how judges will be appointed in the Supreme Court, they said it will be through collegium, but they also said that the tradition of appointing senior most judge of the Supreme Court as Chief Justice of India will also continue. It reiterated the convention of appointment of senior most judges of Supreme Court as Chief Justice of India. तो 1993 के बाद से it is always the senior most judge who will become the Chief Justice of India. This convention will be followed. So how Chief Justice of India will be getting appointed? Senior most judge. And how other judges would be appointed? President will appoint them in consultation with collegium. And consultation means concurrence. It was through the second judge's case. Then came the third judge's case. Third judge's case was not actually a case reaching there, but government ने एक presidential reference डाला था कि यार collegium, देखो in second judge's case it was said that collegium is Supreme Court with senior most judges. But how many senior most judges? All those things were not very well defined. Here they brought clarity on that also. It held that collegium shall consist of CJI and her 4 senior most judges. In case of appointment to Supreme Court, and collegium will consist of CJI and 2 senior most judges in case of appointment to the High Court. Collegium का meaning क्या है? It was clarified in the third judge's case. In second judge's case, what was said? Chief Justice of India along with senior most judges. But in the third judge's case, they cleared it. They said collegium would mean Chief Justice of India along with 4 senior most judges of the Supreme Court in case when the appointments are being made for Supreme Court. And collegium would mean Chief Justice of India along with 2 senior most judges of the Supreme Court when appointments are being made for High Court. But they also said in case of appointment of High Court, collegium will also consult such other senior judges serving in the Supreme Court who had previously served as judge of the High Court. So basically what they are saying in this point is, let's say I am considering promotion of some judge from Bombay High Court to Supreme Court. I am considering promotion of this collegium is considering promotion of some judge of Bombay High Court to Supreme Court. So who will be taking the decision? Chief Justice of India along with 4 senior most judges. But let's say एक और judge है Supreme Court में who came from Bombay High Court in the past. उससे भी consult करना है. What is it saying? Additionally, for appointment to the High Courts, the collegium must consult such other senior judges serving in the Supreme Court who had previously served as judge of the High Court concerned. Got it? समझ में आई बात? तो अगर आपको बॉम्बे हाई कोर्ट में कुछ अपॉइंटमेंट करना है तो collegium 2 senior most judges, Chief Justice of India 2 senior most judges. This is the collegium, but you will also consult a judge in the Supreme Court who may have come from Bombay High Court. But this consultation does not mean concurrence. यहाँ पे consultation does not mean concurrence. Got it? This was third judge's case. Then came the 99th Constitutional Amendment Act. What happened in the 99th Constitutional Amendment Act? A new constitutional body was created, National Judicial Appointment Commission. This National Judicial Appointment Commission was a constitutional body which was supposed to replace collegium in the appointment and transfer process, appointment of judges of Supreme Court and High Court and transfer of judges of the High Court. This NJAC was supposed to consist of Chief Justice of India, 2 other senior judges of Supreme Court next to Chief Justice of India, and Law Minister plus 2 eminent persons. The total 6 people would be there in the NJAC, and they will be taking a call on how appointment should be done or who will be appointed, who will be transferred. All those decisions will be taken by NJAC, National Judicial Appointment Commission, which was created through 99th Constitutional Amendment Act. It was a constitutional body. It was supposed to be a constitutional body. But then came 4th judge's case in 2015. In this case, Supreme Court declared NJAC as unconstitutional. It said National Judicial Appointment Commission जो बना है, it is violating basic structure of the Constitution. As they argued, primacy of collegium was part of the Constitution's basic structure. Collegium के बारे में लिखा भी नहीं है Constitution में, but Supreme Court said primacy of the Constitution is part of the basic structure, and this power could not therefore be removed even through a constitutional amendment. They held that NJAC would lead to violation of independence of judiciary, and thus NJAC was declared unconstitutional. Though this judgment was criticized also, world over judiciary is not the sole body which appoints judiciary, and still judiciary is considered independent. आप US में जाइए, it is not that judges only appoint, Supreme Court का judge is only appointed by other judges of the Supreme Court. So this was criticized too. In UK, the Constitutional Reform Act 2005 established a 15-member commission for choosing the candidates for Supreme Court. But in India, it is collegium system where Chief Justice of India along with 4 senior-most judges decide who will become judge of the Supreme Court. And when we tried to change it, when Parliament tried to change it by bringing National Judicial Appointment Commission, that was declared unconstitutional by Supreme Court. So what is the role of government in the current appointment process? When a lawyer is getting appointed as judge, in that case government is supposed to get a IB inquiry conducted, Intelligence Bureau inquiry conducted. It can raise objection and seek clarification regarding the collegium's choice, but एक बार collegium reiterates the decision, the same decision is reiterated by collegium, government does not have a lot of say. But it has not been provided in how much time government has to accept this recommendation. So when government is not happy with some appointment, they don't accept the recommendation, they do not reject it, but they do not even accept it because there is no time frame. And इस पे अभी debate हो रहा था when Supreme Court asked कि many of our recommendations are pending with you for so many years, or some of the recommendations have been pending for more than a year, but many recommendations have been pending for months. Why are you not working on it? Government has the scope of not working on it because there is no time limit in which the government has to act on the recommendation of collegium. Okay, so why collegium system is being criticized? Why? देखो, there is though Supreme Court has asked government कि why are you keeping these recommendations pending? Why have you not appointed these people? But on the other side, there are criticisms of the collegium system also कि we needed NJAC. We needed NJAC because collegium system suffers from a number of flaws, a number of limitations. First thing is, it was not something that was provided in the constitution. It was created through interpretive gloss. Interpretive glosses, like it was not something which was originally there, but Supreme Court has interpreted the provisions of the constitution in such a way that the real constitution has been glossed over by the collegium system. The provisions in the constitution has been glossed over by the collegium system. So one criticism against the collegium system is this. Then collegium system also lacks transparency. Like how is Chief Justice of India along with 4 judges deciding it? What is the criteria? Why this judge was not appointed as a judge of Supreme Court? Why this judge was appointed? These kind of questions are not answered. There is lack of transparency on this front. जैसे a major issue occurred when in August 2023 questions were raised when one of the country's finest judge in recent times, Justice Muralidhar, was not elevated to Supreme Court. At the age of 62, he got retired. Everyone was expecting that because of his independent nature of judgment, because of the impact of his judgments in the past, he is someone who is senior most, who is eligible to be appointed as a judge in the Supreme Court, but he was not appointed, whereas many of his juniors were appointed. Many of the judges who were not having as much credibility as Justice Muralidhar was appointed. So there is lack of transparency in the collegium process only. Then collegium process is also being considered autocratic, and it is being considered autocratic and it lacks accountability. Why? How? There have been arguments about collegium is promoting nepotism. जजेस के रिश्तेदार हाई कोर्ट में जजेस, सुप्रीम कोर्ट के जजेस के रिश्तेदार हाई कोर्ट में जजेस बन जा रहे हैं. हाई कोर्ट में जज का अपॉइंटमेंट का काम इनको ही करना है. Collegium has to do it, and there have been many such cases. Now, some of them may be eligible, some of them may be very good, but in a country where there are so many people, chances of this happening is very less if things were neutral. when things are not neutral, there is always focus on the focus on relatives of the existing judges may be high. Collegium system mein this criticism has also been there. Then lack of expert body like standing committee to help collegium. Like there is no body as such which is helping collegium in choosing, identifying these are the good people whom you should consider. So here the scope available with collegium reduces. What happened? Here the scope available with collegium reduces drastically. How does it reduce drastically? Because they know a few judges, they know a few lawyers, they will consider people for appointment only from that group, because they do not have a standing committee which is doing independent research. It also diverts judges from judicial work into administrative work, and transferring of judges of high court is a complex process, and there a specialized body which is giving you feedback would have been important. Then collegium system also limits the field of choice. Here I have explained. Delays in appointment of judges. This is another issue. Due to differences between executive and judiciary, this has caused delays in the justice delivery. For example, on 20th September 2024, Supreme Court asked government to explain its reasons for sitting on the names reiterated by the apex court collegium for months or even years together. Why is executive not appointing some, or why president is not appointing some judges even if Supreme Court has reiterated its recommendations? It's happening because there is difference between judiciary and executive. This difference between judiciary and executive would have been done away with if NJAC was working, because वहाँ पे law minister भी हैं, वहाँ पे eminent jurist भी हैं, वहाँ पे 3 ही judges हैं. तो collegium system is also leading to differences between judiciary and executive, which is leading to delays. Got it? So criticisms of collegium system. Why collegium system is questioned. Now, some steps have been taken to reform the collegium system. One step is memorandum of procedure. So when NJAC judgment was given, Supreme Court knew that this judgment will be opposed, like executive will not be happy. So to improve collegium system, what Supreme Court said, executive, you prepared a memorandum of procedure, how collegium system should be, collegium should be functioning, how judges should be appointed. But this memorandum of procedure has not been finalized yet because of differences between executive and judiciary. Executive ने एक condition डाला कि when judiciary recommends someone, executive says नहीं वो appoint नहीं हो सकता, judiciary reiterates it, so collegium reiterates it. Then executive has to agree on that appointment. Here they said if we are rejecting someone, here the executives in memorandum of procedure that got created, executive said if we are rejecting someone on the ground of national security, then reiteration may be that person should not be allowed to, or it should not be mandatory for executive to appoint that person on the ground of national security. So Supreme Court का और collegium का argument है, if in your report you will say कि national security issue है, why would we appoint that person? है ना? But final decision should be with us, not with executive. This difference has led to the entire memorandum of procedure not getting finalized. So one improvement that was suggested after NJAC was a memorandum of procedure should be created which will bring more transparency in the functioning of collegium, but that has not happened. Then resolution to make collegium's decision public on Supreme Court website. Now collegium का जो final decision होता है, that is made public, that is put on Supreme Court website, but still how that decision was reached, what were the criteria considered, all those things are not transparent, and this was one of the criticisms of the collegium system. So what can we do? What can we do to bring in changes? एक तो था कि यार create a body like NJAC, but it seems that in near future that may not be possible because Supreme Court very recently has described that to be unconstitutional. So we should give recommendations to make improvements in the current system. So one recommendation is more transparency on the criteria of merit, norms of selection and the selection process. Why some judges being rejected, why some judges being chosen, usme there has to be more transparency. One suggestion is government can set up judiciary can create a search cum evaluation committee as proposed by Ministry of Law and Justice to bring transparency in the judicial appointment through collegium system. This search cum evaluation committee will take all the applications. There can be a High Court judge who is qualifying to be, there can be a Supreme Court lawyer who is qualified to become a judge of Supreme Court, right? Even that person should be able to apply, other people should be able to apply. It will also be an evaluation committee which will see who are all the judges or who are all the people who are good enough, and then the matter should go to collegium. In the absence of this system, collegium has very little scope, very little set of people that it can look at. Eligibility criteria to judge the performance and suitability must be formulated objectively and must be made public, making collegium decision come under RTI. Collegium decision, not only the final decision, but how judges were chosen. So what we need to bring is, we need to bring more transparency. A secretariat altogether may be created, a secretariat for this purpose, which can specifically do this. It may be under collegium only, but under judiciary only, but specially focused on studying all the judges, studying all the lawyers, choosing right people. This will reduce the administrative work on collegium. Then attracting more talent in judiciary. If we want to improve judiciary, we should also be able to bring in more people, more good quality people in judiciary. And one suggestion for that is All India Judicial Service. Just we have civil services, through which like you will see that in civil services so many people are interested, so many bright people are interested. That doesn't happen in judicial service that much. आप कोई बच्चा judicial service में select हो गया है, वो फिर भी civil services में exam देता है. I have some of my students in your batch जो already judge हैं, जो selected हैं in your classroom, and they are applying for civil services, because in the judicial services system is not as streamlined, how promotions would happen, how growth would happen, whereas in the civil services everything is way more streamlined. तो जो civil services के streamlined processes है for appointment, for promotion, all those things could be brought in judiciary through All India Judicial Service. So another suggestion is we need to have more talent so that collegium will have scope for more number of people who can be promoted from lower judiciary to High Court, and from High Court eventually to Supreme Court, right? Then we should also develop a mechanism to deal with complaints and adverse report. जैसे अभी we would see that a judge in the High Court referred a part of the country as Pakistan or something like that. Those kind of things, उन पे action लेने का कोई procedure होना चाहिए. We have a procedure, we'll talk about it, but it has some limitations. So we need to bring in changes there to make it more effective. Now you will say, sir, how is it related to appointment? देखो, point is, even after getting appointed, judges should be held accountable, good quality of judges should be there. The one reform that we need in the appointment process and uske baad ensuring that appointment judges are functioning properly is this. Okay, so for now, in conclusion, I am saying that for now, possibility of replacing collegium system may not be there, and therefore we should focus on how within collegium system we can make it more transparent, we can ensure that more number of people may be interested, and once the judges are appointed, they are working transparently, they are working in ethical way. उसको ensure करने के लिए भी there should be mechanism to deal with complaints and adverse reports about judges. These are certain things that we should keep in mind. So from what is collegium system to the challenges of collegium system and what should be done. Are we clear about all this?